Well, good afternoon. Yes, just gone 2:15 here. Hi there, Darkside. Got so many articles to get through, but this one was of particular interest to me, even more so when I started watching the first episode of Flint Town on Netflix. So, what is he having on about now? Well, when I read this, my immediate thoughts were with, how would Eric Cozy have been reading this article? He would have been spitting feathers. I know exactly what he would have been like having to read through this. Anyway, let's pop it up. Just make sure everything is working as it should. Yeah, that seems to be okay. So, let's go. Is this the very top? It is actually, yeah. Kim Worthy first came across the name Kim Worthy when the dude was looking at Devontae Sanford case. So this Kim Worthy releases a list of 51 untruthful police officers. This is an article by George Hunter of the Detroit News, and he makes a correction. This story has been updated to reflect that former Detroit police homicide investigator Michael Russell retired from the department. The circumstances of his department were incorrect in a previous version. So, Detroit, former Flint police chief and Detroit police official James Tolbert. James Tolbert is the one at the beginning of Flint Town, is the one who within within the first episode is replaced. He comes across reasonably coherent and okay, so one wonders why they were so keen to get rid of him. Anyway, that's exactly what happened. James Tolbert is among the 51 cops or ex-cops on a list released Monday of officers who have been found to be untruthful. Prosecutor Kim Worthy, who said that if somebody had confessed in the case of Devontae Sanford, once somebody has confessed, even actual innocence is not enough to get them released. In other words, they had their opportunity at court, they confessed, therefore they must suffer for having confessed. Anyway, Prosecutor Kim Worthy, who I can only imagine her real name should be Prosecutor Unworthy, said she planned quarterly public releases of the Giglio list of officers who have been found to be untruthful, either in court or after internal investigations. What is the Giglio list? It's the same as Brady, and it's to do with officer integrity. Let's go through. Just reduce that a little bit. Yeah, that's probably better. Acquaint participants with Brady, Giglio, and their application to peace officer integrity. Provide perspectives as the issues that surround Brady. Identify issues that may present themselves in the future. Give audience examples to developing Brady disclosure procedures for law enforcement agencies. What the heck is Brady? I think we know about that. Oh, but it does actually mention, obviously, here Strickler, which is another one that we hear about, and United States versus Giglio. Bagley and Kyles versus Whitley. Brady versus Maryland, a 1963 murder case. Government had a duty to disclose material exculpatory evidence. Failure to do so violated due process, where the evidence is material to either guilty, innocence of the accused or punishment. There is no regard for good or bad faith of the prosecutor. Let's come on down. Under the Constitution, due process requires the prosecution to turn over evidence favourable to the accused and material to his guilt or punishment. This requirement includes evidence that may be used to impeach the prosecution's witnesses, including police officers. Interesting, as I say, this is an actual police officer that's presented this. This looks very much like the sort of presentation that you would do on a what's the I app, the Apple app. I've used it myself a few times. Keynote, yeah, looks like Keynote, but there's PowerPoint is the other one, isn't it? Yes. Anyway, police officers and police agencies are, for purposes of Brady, considered to be part of the prosecution team. They must therefore make the prosecutor aware of any evidence that may be favourable to the accused. In Giglio, Brady rule includes evidence that could be used to impeach a witness when the reliability of a given witness may be determinative of guilt or innocence. Non-disclosure of evidence affecting credibility falls within the rule, regardless of whether withheld in good faith. In Bagley, no legal distinction between exculpatory evidence and impeachment evidence for purposes of the Brady rule. Good, I like that. Favourable evidence is material if there is a reasonable probability that the result would have been different if defence had known. I don't get that. I mean, who determines what would have been reasonable probability? Harmless error standard does not apply. Issue is whether evidence is material. Why not just hand the whole lot over and let the defence decide what they consider to be, important to them? Except don't ask Kratz to tell you what's going to be worthwhile to the defence. Brendan's computer of no evidentiary value. Is that right, Ken? Kyles versus Whitley. Knowledge imputed to the prosecution includes knowledge that the police may have. Prosecutor has a duty to learn of any favourable evidence known to others acting on behalf of the government. This includes the police. Impeachment and exculpatory evidence. I quite like this. This was some examples that they give. Examples. Government's obligation to disclose favourable evidence under Brady covers not only material exculpatory evidence, but also information that could impeach government witnesses. Agreements, exchanging testimony for money or favourable treatment, the fact the witness suffers from hallucinations, efforts by one witness to improperly influence the testimony of other witnesses, history of untruthfulness, other conflicting statements made by the witnesses. Examples. Prior inconsistent statements of key witnesses. Government witnesses had previously filed a false report, information undermining the credibility of witness identification or defendant. Doctor's report following an autopsy which conflicts with later trial testimony. Example. Detective Jones is handling a rape investigation and develops information of a potential suspect who was seen leaving the scene in a white pickup truck. The investigator displays a photo lineup to the victim and she identifies the suspect, who does own a white pickup. No forensic evidence connecting the suspect to the crime is initially discovered. However, exculpatory evidence. During the course of the investigation, a witness is located during the area canvass who claims to have seen a beige pickup truck in the area driven by a dark-skinned male in his 30s. The identified suspect is a light-skinned male in his 20s. The investigator does not document this information in his report because it contradicts the probable cause he has developed in his case. Brady rule examples. Exculpatory evidence. Detective Smith is handling a murder investigation. He develops a suspect who is of limited intelligence and brings him to the station for questioning. After questioning him over a period of days, he informs the suspect that if he confesses, he will be allowed to go home. The suspect confesses and is taken into custody and charged with murder. Detective Smith fails to document his promise of allowing the suspect to go home in exchange for confessing and does not inform the prosecutor. Detective White is handling a robbery investigation in which a victim is shot. He discovers a footprint near the scene, which he has photographed and lifted. He subsequently arrests a suspect who is wearing a size 9 shoe. The footprint is a size 11 sneaker, and Detective White discards the footprint evidence, believing it is unrelated to the crime. He fails to document this information. Another example is Detective Evans displays photo lineups to 3 witnesses. 2 of the witnesses identify a suspect. However, the 3rd witness fails to identify anybody. Detective Evans documents the 2 positive identifications, but does not document that the 3rd witness failed to identify the suspect, and Detective Evans never informs the prosecutor. Officer credibility concerns. Officer investigated, but no finding of violation. IA finding that officer, internal affairs finding that officer had violated policy not relevant or unrelated to truthfulness. Internal affairs finding that officer made a false or misleading report or statement, finding that officer had violated policy touching on relevant trial or trial issue. Finding that the officer covered up or attempted to cover up. I think what I'll do is I'll pop the link to this document in the description, and you can have a read of it at your leisure. I really wanted to get back to this one here. So anyway, I think we can safely say that yes, the Giglio list is the same as people who have committed a Brady violation of officers who have been found to be untruthful either in court or after internal investigations. And of course there is Mr. Talbot, Police officers who have been found guilty of lying are called Giglio impaired after Giglio versus United States, a case in which the US Supreme Court granted a man a new trial because prosecutors didn't inform the defense about a deal they'd negotiated with a witness not to prosecute him in exchange for his testimony. Monday's list was issued a few weeks later than its scheduled release at the end of the third fiscal quarter. Unworthy said in a statement Monday, because trials are scheduled to resume in January, we thought it was important to send this out to our prosecutors and defense attorneys. In advance of this release, WCPO has notified all police agencies who have a current or former officer on the list. Worthy said, we are continuing to take the additional step of releasing the list to the public because in an era of criminal justice reform, it just makes sense. We plan to review, update, and release this list on a quarterly basis. Now, all of the 51 officers on the list have been separated from their agencies they worked for when they were deemed untruthful. Most of the officers on the list came from the Detroit Police Department, although Inkster, Highland Park, Lincoln Park, and Harper Woods also are represented. It's unclear if any of the officers on the list are still employed as cops. 13 of the ex-officers on the list are in prison. Talbot, former Flint police chief Talbot, is the most prominent name on the list. He was a long-time Detroit police officer who ascended to the rank of deputy chief before becoming Flint's police chief in 2013. He was fired in February 2016, a few months before Worthy publicly accused him of committing perjury. And as I say, the dude up there in YouTube heaven will be spitting feathers. Worthy said Talbot had lied to Michigan State Police investigators about who drew a map of a crime scene involving a 2007 quadruple homicide in a Detroit drug house. The interview came during an MSP investigation into the case of Devontae Sanford, who was 14 at the time of the crime and 15 when he was sentenced to prison for second-degree murder. Although police obtained a confession and Sanford pleaded guilty, it was, again, a terrible interrogation, very similar to Brendan's, which is why obviously the dude covered it. His attorneys contended he was tricked into admitting to the murders. Sanford's advocates also say officials tried to cover up the fact that 2 weeks after he was sent to prison, hitman Vincent Smothers admitted to the crime, providing accurate crime scene details that included where one of the murder weapons was stashed. Well, it's not up to the police to release Sanford. It was up to Kim Worthy. And as I say, her attitude, sold as seen. Once you've confessed, doesn't matter if you're actually innocent. It doesn't matter. After he was fired as Flint's police chief, Talbot was appointed a deputy chief in Highland Park. After multiple protests, wow, this guy is not popular. Talbot resigned last year. Talbot, who also was accused in lawsuits of trying to quash the Detroit police investigation into the April 2003 murder of exotic dancer Tamara Strawberry Green, declined to comment when reached by telephone Monday. Talbot's co-defendant in Sanford's ongoing federal lawsuit, former homicide investigator Michael Russell, also is on the list, which said he gave a false statement. Russell retired from the department. I don't have anything to talk about. Russell texted Monday in response to a phone call seeking comment. Also on Monday's Giglio list is William Robocop Melendez, a former Detroit Highland Park and Inkster police officer. While on Inkster's police force in 2016, Melendez was sentenced to 13 months in prison for the beating of motorist Floyd Dent. Melendez served 10 months in prison before his January 2017 release. They don't make it clear as to who these photographs are. They do when I looked at it on Messenger, but I'm not sure if these photographs are actually of the persons that we've just read about, or whether ones that are about to come up. Former Detroit narcotics officer David Hansberry, Brian Watson, and Arthur Lavelles, who are serving out federal prison sentences after their 2017 extortion convictions, also are on Monday's Gigolo list. An ongoing internal investigation into alleged widespread corruption in the narcotics unit sprang from the extortion case. Well, actually, that wasn't too bad. That wasn't too bad at all. Let's go back and do a little bit more of this Giglio, Brady, and Strickler. As I say, going back to Kim Worthy, most unworthy prosecutor. I mean, her ethics are as bad as Harding's and Kratz's. Trying to make out that she's the good person that's trying their best to reform criminal justice. I think she's just thrown a load of police officers under the bus. The three essential components of a Brady claim are evidence favorable to defendant because it is exculpatory or impeaching, the state willfully or inadvertently suppressing the evidence, and prejudice resulted. That's one of it, I think it was. No. One sec, let me do this. Kyle's versus. Oh, no. Brady and law enforcement organizations and their employees. Question: does Brady mean we have to disclose evidence that does not show the defendant to be innocent, but mere casts doubt on the testimony of the prosecuting witnesses? Answer: yes. Do we? As I say, just hand over the whole lot. What's the problem? Just hand it all over. Whatever you've developed, give it to the defense attorney. Let them decide what is or isn't of worthiness to them. And truthfulness, the term refers to false statements, false reports, or intentionally incomplete statements and reports. You feel like holding a CD in your own personal possession for 12 years, Tom. That is a good example. The false statements involve all aspects of the job, not just enforcement and criminal investigations. See Dreary versus Gloucester, 10-year-old disciplinary finding that an officer falsified overtime records admitted for impeachment purposes. United States William, new trial ordered because FBI failed to disclose that an agent who was a witness at trial had, 15 years earlier, received a letter of reprimand for forgoing an informant's signature on a receipt and lying about the forgery under oath. And bias, yes. I wonder if we can include Angela Sukovich, bias against Stephen Avery. Bias includes prior records allegedly showing an officer's bias against an identifiable group, i.e. African Americans, gays. Bias could also be shown toward a particular person or family based upon prior conduct or statements. Well, that's definitely Thomas Kasurak against Steve. I'm going to get you for it, whether you did it or you didn't. And then when Steve is out, nobody really intended any harm in this. We really thought we had the right guy. Are you right? Crimes committed by officers which must be disclosed include any crimes other than motor vehicle misdemeanors, DV or driving under influence. Even motor vehicle offences must be disclosed to the prosecutor when the criminal case involves similar conduct. So I'm not sure, are they saying that they do have to be included or not included? Crimes committed by which must be disclosed include any crimes other than motor vehicle or misdemeanors. Well, driving under the influence is not exactly a misdemeanor, is it? Wow. Brady and law enforcement organizations and officers. The belief that internal affairs files are confidential and not subject to closure is mistaken. The adage that the defendant is on trial, not the officer, has been substantially eroded. In certain circumstances, the officer's prior conduct is relevant in the criminal trial because that conduct reflects on the officer's credibility. Are pending investigations of an officer subject to disclosure. Disclosure will assure the integrity of a criminal conviction. The general rule is that unverified or speculative information is not subject to disclosure. However, the decision to disclose such information is best left to the prosecutor. I don't know about that. Potential Brady material affecting officers. Misconduct involving moral turpitude and truthfulness. Bias, again, moral turpitude, integrity, presumably moral turpitude is mentioned twice because it's doubly important. Misdemeanor convictions involving moral turpitude. Well, there you go, triply important. Contrary statements about facts of the case. Evidence undermining the officer's expertise. False reports by the officer in other cases, evidence of drug or alcohol addiction. Ultimate use of the information. Brady information must be disclosed to the prosecutor. The prosecutor must then decide. See, See, this is why I think this is wrong. It shouldn't be up to the prosecutor to decide whether to disclose information to the defence. It is very possible, however, that the information may not be admissible in court. Well, fine, give the defence that evidence and then go and argue about it in court. Only that evidence which the court finds to be relevant for impeachment purposes can be used. Oh, the bottom line. The department officers should make sure the prosecutor is aware of any information about the officer that, if revealed, would be favourable to the defence. The department officers must disclose to the prosecutor anything in the officer's background that reflects bias, untruthfulness, or criminal activity. The responsibility to disclose the information belongs to the prosecutor. Let them make the decision. You do not want the agency officer to be held responsible for the retrial of a case due to non-disclosure to the prosecutor. All of this applies to both felony and misdemeanor cases. Prosecutor's ultimate role: prosecution, obtain, review, disclose, argue. Non-traditional sources of Brady material: early warning systems, supervisors' notes, emails, inter-office communication or memorandums, annual employee reviews, judicial report. Now you know the law. How does it actually work? What is the Brady list? How does an officer get on the list? What does being on the list actually mean? Can an officer get off of the list? The Brady list. Okay, here we go. A Giglio or Brady list is a list compiled usually by a prosecutor's office or a police department containing the names and details of law enforcement officers who have had sustained incidents of untruthfulness, criminal convictions, candor issues, or some other type of issue placing their credibility into question. Placement on the list. Police department agencies must disclose information regarding potential Brady, Giglio material to prosecutors. Prosecutors will then review the information to determine what actions will be taken next. Clearly, this is some sort of presentation that new officers, or maybe officers in training, get given. Placement on the list. Both the law enforcement agency and the prosecutor's office should maintain the list of disclosures. Prosecutors will then review the disclosures and make case-by-case determinations as to how to handle the information. What actual issues trigger a Brady disclosure to prosecutors? The following is not about exculpatory evidence, referring to acts, incidents involving law enforcement officers that could call their credibility into question, not just acts of dishonesty. Hamilton County OH prosecutors request the following. Hamilton County, I presume in Ohio, request the following. Any criminal record of any witness or any criminal case pending against any witness whom the prosecution anticipates calling, information known to the department cast doubt on the credibility or accuracy of a witness or evidence. Hamilton County requests the following. Information known to the department regarding any mental or physical impairment of any governmental witness that could cast doubt on his or her ability to testify accurately and truthfully at trial. A finding of misconduct which A finding of misconduct by the Civil Service Commission or a completed internal investigation that reflects on an officer or other member of this department's truthfulness, bias, or moral turpitude. This includes employees under suspension. What else do the prosecutors request? Evidence that a proposed witness has a racial, religious, or personal bias against a defendant individually or as a member of a group. Other information which may be considered as appropriately disclosable Brady material reflecting upon an officer's truthfulness, honesty, bias, or misconduct includes, but is not limited to, the following developed from relevant case law. 1. Lying to superiors during internal administrative police investigations, falsifying police reports or making misleading reports, planting evidence. I wonder if they've got this similar presentation in MTSO. Theft of evidence in police custody, failed polygraphs, inappropriate records checks of detainees or witnesses, any history of lying in the process of testifying or preparing affidavits under oath. Maricopa County Review Process established a review committee for Brady Giglio disclosures. Placement on the Brady list is not automatic after a disclosure from law enforcement. All law enforcement disclosures called referrals are vetted through a committee made up of criminal chief prosecutors and law enforcement liaison. The review process, officers are placed on the Brady list after a preponderance of the evidence finding that the referral is Brady Giglio material. Once a finding is made, the officer is sent a letter describing the committee's finding and will review future administrative findings to determine if placement on the list is still warranted. Cincinnati Police Department policy modeled closely to what the Hamilton County prosecutors requested. Went through the Cincinnati Police Department manual or rules and regulations and matched specific rule violations with Brady requested information, created an SOP, whereas specific violations were deemed mandatory disclosures. Cincinnati Police Department policy, other violations can trigger disclosure, but more investigation is warranted. A database was created where specific violations automatically required additional tasks to close the investigation. Prior to closing, there must be an indication of whether disclosure was made to prosecutors. Can anyone request the Brady list? Jurisdictions treat the information differently. Some jurisdictions are able to send the information directly to the prosecutor's office without any formal request. Other jurisdictions protect personal disciplinary files and are only turned over after specific requests, court motions are filed. Can anyone request the Brady list? It's important to know and understand the law's procedures within your particular jurisdiction. There are other groups that have sought Brady Giglio material lists other than the prosecutor's office. I can imagine that. Media interest in Brady lists. Have officers patrolling your neighborhood been convicted of crimes or lied on the job? So Cincinnati. Here, the police who patrol your community lied on the job or have the police who patrol your community lied on the job or been convicted of a crime? Do you know? Do prosecutors? They're supposed to. A more than 50-year Supreme Court ruling requires prosecutors to seek and disclose evidence to defense attorneys and the accused that is material to his or her guilt or punishment. This includes evidence about their untruthfulness, certain prior criminal convictions, and evidence of bias, excessive use of force. We asked prosecutors across the tri-state, from Hamilton County to Rowan County to Northern Kentucky, to give us their lists or a copy of their Brady list. Most said they do not keep an actual list, and some told us they don't have any issues, so there simply is no need for one. One prosecutor is even proud to say he keeps information from the public. In Butler County, eggs are still cheaper in the country, Prosecutor Mike Moser said. I can still do it without a list. I can do it through the grand jury. It keeps it secret that way. The Hamilton County Prosecutor's Office does keep a lengthy and detailed list, one that currently has more than 100 officers. They promptly handed it over a few hours after we asked. We looked for anything that a defense attorney might be able to use to impeach an officer's testimony, yes, such as untruthfulness, being fired for using excessive force, making racial slurs, etc., said Julie Wilson, a spokeswoman for the prosecutor's office. We rely on law enforcement agencies to send us the information, and after we review the information, we decide who goes on the list. Each police department agency is responsible for notifying our office of officers in their employ who potentially have Brady issues. Prosecutor Dieters periodically sends a letter to each department agency reminding them of their obligation in this regard. Their list includes mostly officers from Cincinnati Police and deputies or correction officers from the Hamilton County Sheriff's Office, the two largest agencies in Hamilton County. Some of the highest rankers officers in the list include two who appear on there twice. List people on the list, they've blotted out the name for some reason. Brady websites, bradycops.org website attempting to compile a national list of officers placed on Brady lists. That would be very helpful, wouldn't it? Or would it simply be a list of those that have been caught, knowing full well that there's others that are yet to be caught? Consequences of placement on the Brady list: stigma or damage to officers' reputation, limit job assignments, limit advancement through the agency, possible termination if the officer is no longer credible to give testimony and no other administrative assignment is available in the department. If you are a chief or sheriff, what do you do? Retire. Hey, Tom Kasurik and Kenneth Peterson and Robert Herman, just ask them. Can an officer be removed from the list? Okay, an original disclosure that is later determined to be unfounded or not sustained could be a basis to remove the officer from the list. And some courts have required a removal from the list after an arbitrator has exonerated the officer. That depends. The great lawyer answer. I can imagine Travis having a wee chuckle at that one. That depends. Trends. Legislative intervention. 13 states have passed legislation specific to Brady lists. Check your state and prosecutor. Legislate notice. We've nearly finished. What's that you want me to do, Diane? Do I have to sign it? Do you want me to fill it out?
Yeah.
Okay, I can do that. So I've just been given my next terrible and tricky assignment to sign a birthday card. Anyway, let's carry on. Legislate, notice, ability to appeal, restorative justice, ability to get off the list, personal actions. I think, wow, we've got to the last one. Questions? As I said, as I said all the way through that, I mean, seriously, why not just give all the information over to the defense and let them decide? And if they've given stuff over to the defense, okay, and then they want to argue about the relevance of that information, let's do that in the court. Let's let the judge be the decide. What's the judge there for? Let the judge decide what's relevant. Come on, that's surely the way forward. Anyway, I will endeavour to pop the link to both of that. Well, it's quite interesting, the Brady Giglio from the police officer's point of view. But as I say, that Kim Worthy, pointing the finger at police officers, and she's far worse than some of them. Anyway, that'll do fine for today. We'll catch you all again soon. I've got something lined up for tomorrow because it's the start of Hanukkah. So I'm going to have a look at an article focusing on Brendan and Steve Drizzen, but actually from the sort of Jewish point of view. So that's quite interesting. And dark side, I hope you get to enjoy that spanner wisely. The rest of you, see you again soon. Cheers. Bye for now.